In this video, we're going to talk about the concept of patent ownership. As we've already discussed, a patent gives the owner powerful rights to exclude others from making, using, selling, or offering to sell the invention covered by the patent claims. But who actually holds these rights? As we discussed in the video on inventorship, the inventor is the initial owner of these patent rights. So it all starts with the inventor. The inventor can transfer ownership of these patent rights, but that transfer has to occur through a written IP assignment agreement. Now, you may have heard of the concept of a work for hire, but it's important to note that the work for hire doctrine only relates to copyrights. It does not relate to patents. So it could be the case for copyright material that an employer automatically owns the copyrights that an employee creates during the course of his or her work for the employer. But that's not true for patents. It is true that employers typically own the patent rights in inventions created by their employees. But that occurs because there's a written contract, typically an employment agreement or related documents, that contractually assign those patent rights from the employee to the employer. That transfer of ownership does not happen automatically. Now, this is important when we talk about the context of tech startups. Let's look at the example of a technology startup at the point of formation. Let's pretend we have founder 1 and founder 2 that have been working on an idea and have decided to launch a startup venture. Now, in your standard suite of formation documents, whether this is a Delaware C corporation or perhaps an LLC in your home state, there's going to be some documents that are specifically used to transfer intellectual property from the founders to the startup company. One of those documents is what we call a PIA, a Proprietary Information Invention Assignment Agreement. Sometimes it's called a CIIA, a Confidential Information Invention Assignment Agreement. This document is used to transfer intellectual property created by the founder during the course of his or her work for the startup, from the founder to the company. Now, if the founder's already been working on this idea prior to startup formation, there's also going to be another document, we may call it an IP assignment agreement, that transfers any existing intellectual property rights that the founder has at that time from the founder to the startup company. It's important to make sure that you document the transfer of intellectual property, both created by the founder during the course of work going forward with the startup company and any existing intellectual property that exists at the time of formation. Now, there's some magic language that's going to exist in these documents. Typically, a transfer of intellectual property needs to have magic words, and they include hereby assigns and all right, title, and interest. There are some cases that have said that when a document just says a person agrees to assign, or perhaps that all rights shall be the property of another, that those documents are just contractually binding one to later assign their rights to the company. They actually don't themselves transfer rights to the company. So it's important to use the words hereby assigns so that that document presently transfers rights to the startup company. Now, a situation that commonly comes up is that there's a third person, we'll call them departing founder 3, that has worked with founder 1 and founder 2 on this idea, but has decided not to go forward with the startup venture. It's important to have departing founder 3 transfer their rights in writing to the startup company. Otherwise, there's the risk that departing founder 3 could be a joint inventor of some of the technology that's going into the startup company, and therefore could have joint ownership rights in that technology. Unless they transfer their rights in writing to the startup company, that departing founder could later have the rights to use that technology to assign their rights to someone else, and could undermine the important exclusive rights that the startup company seeks to have in its technology. Another question that comes up is, should founders license their rights to the startup or assign their rights? Well, industry standard is to have founders assign their rights to the startup company. And most investors are going to insist that the startup company actually owns all the rights in the inventions created by the founders or others working for the startup. The only exception to that is in the context of university startups coming from tech transfer operations. There, typically because it's required by government regulations, a university will license, either exclusively or not exclusively, their rights to the startup company. There will not be an assignment of those rights to the startup company. And that's the concept of patent ownership.